JosephShine versus Union of India, 2018. Is adultery a criminal offence? JosephShine case struck down Section 497 of the Indian Penal Code, which criminalized adultery. It expanded the horizons of individual liberty and gender parity. The court referred to the Puttaswamy judgment in decriminalizing adultery. Background: Section 497 of the Indian Penal Code 1860 makes adultery a punishable offence against whosoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent or connivance of that man. It goes on to state that in such case, the wife shall not be punishable as an abettor. The stated objective of the law is to protect the institution of marriage. The offence applies only to the man committing adultery. A woman committing adultery is not considered to be an abettor to the offence. The power to prosecute for adultery rests only with the husband of the woman. The constitutionality of the section was challenged for the first time in 1954. However, the scope of the challenge was limited then, and it was based on the exclusion of women from punishment. The section was again challenged in Saumitri Vishnu versus Union of India case and Yusuf Abdul Aziz versus State of Bombay case. However, the Supreme Court upheld its constitutional validity. JosephShine, a hotelier from Kerala residing in Italy, filed a petition under Article 32 of the Constitution challenging the constitutional validity of Section 497 of the IPC and Section 198 Clause 2 of the Code of Criminal Procedure. Arguments: The petitioner contended that Section 497 is manifestly arbitrary and amounts to a violation of the constitutional guarantee of substantive equality. The operation of Section 497 is a denial of equality to women in marriage. It places a husband and a wife on a different footing in a marriage. Though adultery is considered to be an offence relating to marriage, the legislature did not penalize sexual intercourse between a married man and a single woman. Section 497 is destructive and deprives a woman of her agency, autonomy, and dignity. It is founded on the notion that a woman, by entering upon marriage, loses, so to speak, her voice, autonomy, and agency. Section 497, based on the patriarchal conception of the woman as property, entrenches gender stereotypes. On the other hand, adultery must be retained as a criminal offence in the IPC as it has the effect of breaking up the family, which is a fundamental unit in society. Judgment: Section 497 exempts a woman from being punished as an abettor. The underlying exemption is the notion that a woman is a victim of being seduced into a sexual relationship with a person who is not her husband. The exemption seeks to be justified on the grounds of being a provision that is beneficial to women and protected under Article 15, Clause 3 of the Constitution. Discrimination, which is grounded in paternalistic and patriarchal notions, cannot claim the protection of Article 15, Clause 3. The court observed that the principle on which Section 497 rests is the preservation of the sexual exclusivity of a married woman for the benefit of her husband, the owner of her sexuality. Such patriarchal underpinnings of Section 497 render the provision manifestly arbitrary. It violates the non-discrimination principle embedded in the Article 15 of the Constitution. In that, it reinforces the notion that women are unequal participants in a marriage, incapable of freely consenting to a sexual act. Thus, Section 497 violates Article 14 of the Constitution. The court also held Section 198 Clause 2 of the CRPC, which contains a procedure for prosecution, shall be unconstitutional only to the extent that it is applicable to the offence of adultery under Section 497. Importance and impact. In the words of the then Chief Justice Deepak Mishra, it is time to say that the husband is not the master of a wife.